Next is a lady that's, she's a rock star at what she does. What can I say? It's Miss Kathy Brown. Let me get this right. Give me a chance. I'm gonna hook this phonics. Van Zutphen.
That's it.
Ooh. She is over elder care, law, and estate planning. She is the sex, drugs, and rock and roll of law. Ooh, we used that word this morning. I can't wait for us to hear from her. She has many roles: spouse, parent, caregiver, board member, and attorney. Having practiced law for 25 years, she initially worked as a litigator in law firms handling insurance defense. However, after her father developed Parkinson's disease, she became a caregiver for him and was involved in developing in the elder law area, which led her to form Coastwide Law LLC, where she focuses legal practice on individuals, families, and small businesses in the areas of elder law, trusts, estates, and successions, automobile, trucking accidents, business law, and general civil law. Miss Kathy Brown Van Zutphen.
Good morning. Good morning. Thank you. I hope you've had enough coffee this morning. I was talking to Sheena. There was a guy I met in Natchez, and he was giving me some coffee, and he said, "I like my coffee like I like my women." And I said, "Does that mean strong and black?" And he said, "No, that means ground up and in the freezer." So anyway, so I'm an attorney. I practice law here on the coast. Well, I'm actually licensed in 3 states: Alabama, Mississippi, and Louisiana. But I do, as I said, I started off in litigation, but now I do primarily a practice that involves estate planning, trusts, elder law care. So the first thing I have to give you is a disclaimer. Before I can help you or a family member, that person must have legal capacity. So what does that mean? It means the person knows, basically, the legal definition is something like they know what they own and who they want to leave it to. So they have to be able to come in and talk to me about what they have and how they want to handle it once they pass away, or even how they want to set up things while they're still alive. And yes, they can control things from the grave. Usually when I tell people that sort of piques their interest too. But anyway, before we can do any of that, they do need to have legal capacity. So if they've already been diagnosed with Alzheimer's or some other debilitating disease, it's probably too late. So talk to me early. But, so that's a disclaimer. So now for the fun stuff. While you're here today, you want to hear about drugs, sex, and rock and roll, or everything you ever want to know about estate planning, but you're afraid to ask. So we'll start off with the drugs. So a trust is a good thing to, especially if you have a loved one that may have a substance abuse problem or something. And I don't mean that kind of trust. I mean, a trust is a legal document in which you state how you want your assets handled, both while you're still alive and after you pass away. So when you have a family member that has a substance abuse problem or a gambling problem, this is ideal for a way to handle it. Because obviously assets can be squandered, but inherited assets or money can always be squandered, and that's always a concern. If I leave this to my son or whoever, they're just going to gamble it away or use drugs and waste it all, or whatever the case may be. But the even bigger concern is that if the loved one gets a windfall, and they can even use the money to hasten their own death if they have, for instance, a substance abuse problem. So it's always good to come and talk about a plan when you have a loved one that has some kind of special needs. And it can be, like I said, dementia, schizophrenia, some other type of situation. Just any time that loved one cannot handle their own business assets, take care of themselves, that sort of thing. And again, the reason that's important is because money doesn't stop self-destructive behavior, it only intensifies it. And that's another thing. I had someone come to me who had a family member who was schizophrenic. She would take off. She would get in her car and leave and run off, and nobody knew where she was. And they were like, how can we stop that? How can we control that? And I tell them, really, the only way you could control a person in that situation is by controlling the money. Because if she gets in her car and she takes off, if you controlling the money and you cut the money stream off, well, when she runs out of gas, she's got to stop. Or if she doesn't have money for an airplane ticket or a bus ticket or a hotel room. Eventually they'll have to come back because they're out of money. So that's really the only way you can control that type of behavior is by controlling the money, and they have to come back. So in all those situations, a trust can help. In a trust, you would name a trustee to oversee and manage the assets. And quite often, especially in some of these family dynamics where there's a lot of contention, like with a family member who has a mental illness or a substance abuse problem, it's good to have a corporate trustee because then you're not having to fight with a person. And corporate trustees are very well equipped at telling people no. Can I have $10,000 to go to Vegas? No, or whatever. You can also have requirements in a trust, such as requirements for the distribution of income, such as the person may be required to do drug testing or other such things in order to keep them hopefully within the boundaries and not off on a tangent. The other good thing about that, of course, is that the trust can provide some creditor protection for that beneficiary. If that person runs up a bill with wherever, the person can only come against them or garnish the income that they receive. The creditor could not access the principal of the trust fund. So that provides, again, another layer of protection for a family member that has one of these issues. All right, so now I'm going to move on to the topic that y'all really all want to hear about. That's sex. So, thank you. Anyway, so I have this question a lot from people. I can't stand my son's wife or my daughter's boyfriend or whatever. What can I do to ensure that the money doesn't end up with them? You're trying to make an estate plan. You want to either a will or a trust, but you just really don't want whoever to get it. How can I handle that? Well, you can disinherit a child in a will, but you cannot put a provision in a will that the child cannot, or limited inheritance, so that the child cannot get married or must get a divorce or cannot divorce or must change a religion or remain in a certain religion. That you cannot do just because the Supreme Court, of course, have said we have a freedom of religion and people have the freedom to marry, so you can't limit their inheritance based on that. But in a trust, you can put provisions on it. For instance, if you have a daughter or a son and they have a child by a person that either they're married to or not married to, you can put some provisions like that money is to be used for certain limited things like the care of the child, or maybe if the person needs some money for rent or a place to live. So you can put some provisions in there to sort of protect the money, so to speak, in a trust. So that's a way you can sort of protect the money from that whoever, that person that you can't stand, that you don't trust, that you think's just going to get the money and squander it. There's also something in the state of Mississippi. When it comes to assets, there is a legal difference between being shacked up and being married. In Mississippi, there is no such thing as common law marriage. They had it in the state before 1956, but the legislature passed a law in 1956 basically doing away with common law marriage. So there are marital rights that are in the statutes in Mississippi that you get even if you do not have your name on a deed or on a will there's a legal difference between shacking up and being married, in that if you're married, you get some property rights. It's a public policy. The state of Mississippi does not want someone to die and impoverish their spouse. So there's things like homestead rights, widow's allowances or widower's allowance, et cetera. And it's all designed just to keep from impoverishing a spouse. So you need to know that if that's the situation. I had a situation where it was sad. A lady had lived with a man here in the state of Mississippi for 30 years, but they were not married. He did not have her name on the deed to the house. He did not leave a will leaving her anything in a will. And her name wasn't on any of the accounts. So she, of course, we said, we're opening this estate on behalf of his children. He had children from a previous marriage. And, you have to get out of the house. And she was like, I'm not going to leave this house. This is my house. I've lived here for 30 years. But unfortunately, she was not married, and she didn't have any basis to make a legal claim for the house. So we ended up having to have a legal proceeding and then eventually get the sheriff to evict her. So there is a difference between marriage and not being married in the state of Mississippi. Now, I've had some people ask me, well, what if I have property in a different state that does recognize community property? Well, that would go according to the laws of whatever state the property's in. But in Mississippi, property in Mississippi, the Mississippi laws would apply. Here's another thing. If you've been married for 9 years and you come to me and you say, I want a divorce, I'm going to recommend that you wait 1 more year and wait 10 years before you get a divorce. The reason for that is if you've been married to someone for 10 years, you can claim on their Social Security benefits. Once you reach the age where you're entitled to start drawing Social Security benefits, you can claim on that previous spouse, even if you're divorced, if you've been married to them for 10 years. So that's another little tidbit I like to tell people. Now, of course, one of the things that we see more and more every day, and I have a lot of people come in with this situation, and it's what I call a blended family. You've got, had a previous marriage with children, he's had a previous marriage with children, then sometimes they have children together, his, hers, and ours, and they want to know how to deal with that. So what happens if he has kids and then you have kids by a previous marriage and neither one of you have a will or a trust when you die? Well, it goes according to the laws of intestacy. In the state of Mississippi, by statute, there's a law that says, okay, this is the way we're going to do it. And it's basically next of kin, but it's blood kin. So what that means is that stepchildren do not inherit. And for my mother, that was a real issue. So this situation happened to my mother. My mother's father had 3 children, herself, her brother and sister, and her father passed. First, she remarried. She had some children, and then they had children together. But my mother's father died first, left the house, no will, but the house went to his wife. She lived many more years, and then she passed away with no will, and the house went to her children, not the stepchildren, who happened to be my mother and her brother and sister, whose father was the original one that owned the house. She thought that was very unfair, but that's just the way the law is. So if you're in that kind of situation, you need to talk to an attorney. They're giving me this sort of speed up sign because, okay. So if you are a member of the LGBTQ plus community, you really do need a will. And I put some statistics to tell you why that is. Only 27% of heterosexual adults are unmarried, but 47% of the LGBTQ plus community are unmarried. I put some more statistics in there, like only 10% are married to a same-sex partner, 6% are living with a same-sex partner, 11 are living with a different sex partner, 16 and 5 are divorced, and 3 are separated. But the reason I put those statistics in there is showing they're a lot less likely, although they do have the right at this point to get married, they're less likely to get married, or at least statistically, they shows they don't get married as much. And that means they don't get those protections, those marital property protections that I was telling you about. So therefore, they really do need to address it and get a will. All right, rock and roll. What can we learn from rock and roll? Some rock and roll case studies. Tom Petty's estate was free falling. I can't sing. I wanted to get with the guy so he'd play a little music for me, but I didn't get to him in time. But Tom Petty, whoops, wait a minute, let me go back. Tom Petty had an estate worth millions when he died from an accidental drug overdose in 2017. He died with a current wife and 2 daughters from a previous marriage. His trust stated that his wife and 2 daughters were entitled to participate equally in the management of his music empire, but it became a legal battle. What does participate equally mean? Did the 2 daughters get 2 votes and the current wife get 1 vote, meaning the 2 daughters could control and outvote the wife? Anyway, it was a big legal battle, and after a $5 million lawsuit, after attorneys earned $5 million off the estate, they finally reached an agreement that they would all have equal standing, which I still not sure what that means, but they came up with a settlement after $5 million lawsuit. Prince's family said, let's go crazy after he died without a will. There was a mostly elderly half-brothers of Prince, and the IRS valued his estate at between 150 and 160 million. And so it became a battle with his family, a 6-year battle. And during that 6 years, 2 of the heirs, his half-brother Alfred Jackson and a half-brother John Nelson, died during the 6-year battle. So they didn't even get really to enjoy any of that. Bowie's estate plan needed some changes. He had left a will, and he left $2 million to his assistant and $1 million to his nanny. But then he left his remaining assets, half to his surviving wife and half to his children. And his estate was valued at over $100 million, so they didn't do proper tax planning. It ended up he owed about $18 million in taxes, his estate did. So in all these situations, a trust could have helped. I threw this in because another thing I'll say quickly is that pets, people can also take care of pets. The largest trust I've ever done was for $6 million, and the first line of that trust was that the cat was to be cared for. So I wanted to be the trustee so I could take the cat to see the Eiffel Tower and, all of that, because there was no limit on what could be done for the cat. But people do, and charities, one of the largest charities are prevention of animal cruelty, stuff like that. People remember those charities in their wills. I also do car wrecks, so in a wreck, I will get you a check. I just want to throw that in. If you have any questions, my table's over there, and I'll be happy to talk to you, and I'm sorry I probably ran over into somebody else's time because I talk a lot. I'm sorry. Nice to see you. Bye.